News, Seattle.
Sahar Aziz is a distinguished visiting professor at the Boston University's School of Law and joins us now. It's very good to have you with us. In terms of the effects this could have, what are the implications of the court's impending decision?
Well, what it will likely do if it rules in favor of Mississippi and essentially upholds the law that would prohibit abortion after 15 weeks, it will signal to at least 22 other states that they also can pass laws that will prohibit abortion for possibly less than 15 months, 12 months, 10 months, because ultimately what Mississippi is arguing is that the court abandoned the viability test, which was established in 1992 in the Planned Parenthood v. Casey case. And that essentially found that the 14th Amendment's protection against the protection of a person's liberty without due process of law, the way that that's interpreted for a woman is that her bodily integrity, her physical autonomy cannot be compromised by banning abortion before the viability of a fetus. And so that tends to be around 16 weeks is what the medical professionals will say. And so if you abandon that viability test, then now it's case by case, and states can come up with all kinds of random tests or just say it's up to the legislatures or it's up to the judges. And there will be a race to the bottom because many states already have trigger laws, which is as soon as Roe versus Wade is overturned, then these laws go into effect and they effectively ban abortion outright.
How does the court reach its ruling on this? Do each of the justices go and make their own minds up and then we get that final tally? Or could it be that they discuss it and it comes down to how persuasive some are in the arguments they put to their fellow justices?
Yeah, that depends on that particular court. And sometimes they will discuss and deliberate beforehand. Sometimes they won't. Sometimes they'll distribute draft opinions, especially if it's a close call. But ultimately, the question here is that you have 6 judges who have gone on the record, at least prior to when they were justices, and have expressed their personal policy preference against abortion. And so the test is when they testified before Congress during their confirmation hearings and they were asked, will you uphold Roe v. Wade? The answer of all of them was, my policy preferences will not interfere with my independence and impartiality in upholding the U.S. Constitution. And so the question now is, will they follow precedent, which is Roe v. Wade and Planned Parenthood v. Casey, and uphold a woman's right to abortion, or will their policy preferences against abortion influence their decision, even if that's not what they admit? Okay. But the key here is, will they say, well, we're not banning abortion. We're simply allowing states to regulate abortion
on a state-by-state basis rather than a federal basis. Just because we're a slight push for time, but I just want to ask you, would there be any situation where if the conservative-leaning court does limit or restrict the rights of women to have abortions, is there any situation where the president could step in and then and try and amend the law to effectively overrule the court? And if so, what does that do for the legitimacy of the court going forward?
Right, well, first, there's a Washington Post poll that finds that 2 in 1, that Americans support Roe v. Wade 2 to 1. So there's a very strong support for the woman's right to choose whether to have an abortion or not. Now, if the Supreme Court finds that the Mississippi law is constitutional, then this is now a state law. And federal law cannot, at that point, federal law is very restricted. And so it would essentially be Congress passing a law telling states that you cannot have a law that bans abortion. But then that's going to be a separation of powers problem. They'll come back and say, no, the court said we could. Okay,
a decision that has far-reaching implications. Thank you very much indeed, Sahar Aziz. We must leave it there.
Thank you.